In a tense Senate Judiciary Committee hearing, the air crackled with accusation as Senator Kennedy zeroed in on Attorney General Pam Bondi, probing the propriety of Special Counsel Jack Smith's investigation into the phone records of 8 sitting United States senators. The stakes couldn't have been higher. The sanctity of privacy for elected officials clashed head-on with the Justice Department's pursuit of potential criminality. Kennedy's sharp, hypothetical-laden questioning painted a vivid picture of a telecommunications company, AT&T in his scenario, facing a subpoena demanding sensitive records without clear justification. "They'd ask me what planet I just perished from, wouldn't they?" Kennedy quipped, his southern drawl cutting through the room's gravity, underscoring the audacity of such a request. The exchange wasn't just about procedure, it was a challenge to the very boundaries of governmental power. Could a special counsel, unchecked, pierce the privacy of senators without ironclad cause? Bondi, composed yet evasive, deflected specifics, citing the inability to discuss ongoing investigations. Her restraint only fueled Kennedy's persistence as he pressed on the potential liability of telecom companies and federal agents alike. The hearing's emotional core lay in the unspoken question. Had the Justice Department overstepped, risking a constitutional crisis, or was there a hidden crime justifying such bold measures? This wasn't merely a procedural spat. It was a battle over trust, accountability, and the delicate balance of power in a democracy under scrutiny.
General, welcome. Let's suppose that I'm appointed special counsel at the Department of Justice, and I go to the telecommunication companies, the phone companies. Let's single out AT&T, and I say, "Look, I know you're busy, but I want to see a copy of the phone records of a sitting United States senator." They're not going to just give them to me, are they?
No, Senator, of course not.
In fact, they're probably going to ask me what planet I just parachuted in from, aren't they?
Yes, Senator.
They're going to tell me to come back with a subpoena, aren't they?
Yes, Senator.
Okay. What do I have to show in that subpoena to get those phone records of a sitting? Did I mention it was a sitting United States senator? I can't remember. What do I have to show to get the phone records of a sitting United States senator?
Yes, Senator, there were actually 8 sitting United States senators.
Yeah, I heard that.
And you would have to have cause.
I'm sorry, what do I have to show?
You would have to have cause to get the subpoena.
Good cause or probable cause?
Probable cause.
Okay. Probable cause, or if it's a subpoena deuces take 'em, good cause, to show what?
You would need good cause for a subpoena ducis tecum, and what you would have to show is that you believed a crime had been committed, or there was a possibility of a crime, or that could lead to other crimes. We frequently, in criminal enterprises, subpoena cell phones.
By the sitting United States senator?
Senator, they would have to have believed you were part of a criminal conspiracy, is my understanding.
Would a judge have to sign off on it? On the subpoena?
Yes, Senator. Well, for a subpoena ducis tecum, Jack Smith probably took it straight to the judge.
Now, the phone companies, particularly their general counsel, if they're worried about civil liability, even with a subpoena to get the phone records of a sitting United States senator. Did I mention it was a sitting United States senator?
Yes, Senator.
The general counsel for that phone company, let's say AT&T, they have the right to seek to quash that subpoena, don't they?
Phone companies frequently do that.
Yeah. And a smart general counsel for that phone company is going to call the sitting United States senator and say, "Would you like to weigh in on this? Would you like me to quash the subpoena? We're talking about invading someone's privacy here by a sitting United States senator." Could the general counsel for the phone company do that?
Well, Senator, if they believe that a crime could have been committed, they could not tip off the person who committed the crime. Again, I can't comment on details of this particular case.
I'm just asking you theoretically.
I've never seen you commit a crime, Senator Kennedy.
But let's suppose, okay, they didn't want to tip off the sitting United States senator. But the phone company and the general counsel for the phone company, or companies, if there were more than one involved, could say, you know, this is serious as an aneurysm. This is serious as 4 heart attacks and a stroke. This is a sitting United States senator. So general counsel would likely advise the CEO, well, you need to file a motion to quash. The telephone companies could have contested those subpoenas, could they not?
Hypothetically, yes, I can't talk about the facts of this particular case.
We're talking hypothetical.
Senator, subpoenas are issued all the time through phone companies working with the general counsel.
But they can file a motion to quash.
They could, yes.
Yeah.
In any case.
And if they should have filed a motion to quash, and a reasonable person would have filed a motion to quash, because this is a sitting United States senator, and they didn't file a motion to quash, they would incur civil liability, wouldn't they?
Senator, typically phone companies follow a subpoena from a United States attorney.
No, they do, but they don't have to.
They could challenge it, Senator.
Yeah. And if they don't challenge it, they better have a damn good reason. Right? Right?
Senator, I can't talk about the facts of this particular
This is just
case.
a hypothetical.
In general, hypothetically, Senator, maybe they didn't recognize any of the names of the 8 sitting United States senators.
Hypothetically.
That was a joke.
Or maybe they should have gone to Amazon and buy some testicles online. Instead of just saying, sure, I'll just show you the phone records of a sitting United States senator on the basis of an administrative subpoena. Now, do you have copies of the subpoena applications for these
Senator,
8?
Senator, I can't discuss anything regarding this
You can't
case
even
with
tell me if you have copies?
I can't discuss any of this.
All right,
with
when
you,
are you
I'm sorry.
going to, General, when are you going to be able to discuss it?
I can't discuss whether there is or is not a pending investigation,
I understand,
Senator.
but
This was
let's
just
assume
brought to light
if
by
there is a
Director
pending
Patel.
investigation, I don't want this to get swept under the rug, okay? Because I think you're going to get pushback from all quarters. I think the telecommunication companies are going to be all over you like a bad rash because they've got liability here for just turning over these records when they knew what was going on. I think some FBI agents may have some liability here. I think a special counsel might have some liability here. If I were your special counsel and you had appointed me and I wanted to get the records of a sitting United States senator, is that something you would expect me to tell you as Attorney General of the United States?
They better have.
Yeah.
And
Do we know in this instance of the 8 sitting United States senators if they told Attorney General Garland?
Senator, I just learned about this very recently, as did Director Patel, and we cannot discuss the details. I don't know many of the details.
Well, maybe we ought to get Attorney General Garland here. Do you know if the special counsel told FBI Director Wray? Is that something? Let me put it another way. If I were your special counsel and you were the director of the FBI and I'm trying to get the phone records of a sitting United States senator, did I mention it was a sitting United States senator? Is that something that you would expect me to tell you as director of the FBI?
In general, I would believe the FBI would help execute the subpoenas.
Yeah.
To the businesses.
Okay, I want to switch to another subject in the 12 minutes that I have left, since everybody else got to go over. I've got to ask you about this, General. Secretary Howard Lutnick on October 1 gave an interview to the New York Post about Mr. Epstein. And he described Mr. Epstein as, quote, the greatest blackmailer ever, close quote. Have you reviewed that transcript of that interview?
I have not reviewed the transcript, but I saw the clip of it.
Okay. It appears that Secretary Lutnick was Mr. Epstein's next door neighbor. In fact, their townhomes shared a wall. And the reporter that was talking to Mr. Lutnick, she asked how other prominent men could have been associated with Epstein when Mr. Lutnick could immediately sense that he was a, quote, pervert. And then Secretary Lutnick said, or rather the reporter said, did they see it and ignore it? Do you remember that from the interview?
I do.
And Commerce Secretary Lutnick said, no, they participated. And then Commerce Secretary Lutnick goes on to say, quote, that's what his MO was. You know, get a massage, get a massage. And what happened in that massage room, I assume, was a video. This guy was the greatest blackmailer ever, blackmailed people. That's how he had money, end quote. Is that true?
Senator, as our July memo said, we did not uncover evidence. This case has gone through 3 administrations, as well as former U.S. Attorney Alex Acosta.
I know that, Pam, but have you interviewed Secretary Lutnick?
No, Senator.
Do you plan to?
If he wants to talk to the FBI or the FBI wants to talk to him, that is more than on.
Don't you think you ought to talk to him after this interview?
Senator, if Howard Lutnick wants to speak to the FBI and if Director Patel wants to speak to Howard Lutnick, absolutely.
Okay. Maybe we ought to get Mr. Lutnick in here too, Mr. Chairman.
The Senate Judiciary Committee hearing unfolded as a high-stakes confrontation, with Senator Kennedy leading a pointed interrogation of Attorney General Pam Bondi regarding Special Counsel Jack Smith's investigation, which allegedly involved accessing the phone records of 8 sitting U.S. senators. The core issue was whether these actions, executed through subpoenas to telecommunications companies like AT&T, adhered to legal standards or represented an overreach of federal authority. Kennedy's questioning, steeped in hypothetical scenarios, sought to expose potential procedural flaws and the broader implications for privacy and accountability, while Bondi's responses aimed to maintain discretion amid a sensitive investigation. Kennedy opened with a vivid hypothetical, placing himself in the role of a special counsel requesting phone records from AT&T for a sitting U.S. senator. He pressed Bondi on the legal thresholds required for such a request, emphasizing that telecom companies would not comply without significant pushback. They're going to ask me what planet I just perished from, aren't they? He asked, drawing a nod from Bondi. She confirmed that a subpoena would require good cause or probable cause, typically tied to evidence suggesting a crime, such as a senator's involvement in a criminal conspiracy. Kennedy's repetition of sitting United States senator underscored the gravity of targeting elected officials, amplifying the hearing's tension. The senator's line of questioning zeroed in on the process. He asked what a special counsel would need to show to secure a judge's approval for such a subpoena. Bondi reiterated the need for probable cause, noting that a judge would scrutinize the request to ensure it met legal standards. Kennedy then shifted to the telecom company's role, pointing out their right to file a motion to quash a subpoena, especially given the sensitivity of a senator's records. He suggested that a smart general counsel at AT&T would likely contact the senator in question, seeking to avoid civil liability. Bondi acknowledged this possibility, but cautioned that tipping off a potential suspect could be problematic if a crime was suspected, though she avoided specifics about the Smith investigation. Kennedy's persistence revealed his concern. If telecom companies failed to challenge a subpoena for a senator's records, they could face significant liability. They better have a damn good reason, he declared, pressing Bondi on whether such failures occurred in the Smith case. Bondi, maintaining her guarded stance, repeatedly stated she could not discuss the specifics of an ongoing investigation, frustrating Kennedy's efforts to extract clarity. He speculated that telecom companies might not have recognized the names of the 8 senators involved, a remark he quickly clarified as a joke. But the underlying point was serious. Had procedural safeguards been ignored? The senator escalated his critique, suggesting that both telecom companies and federal agents, including the Special Counsel, could face liability if the subpoenas were improperly executed. He asked whether Bondi, as Attorney General, would expect to be informed if a Special Counsel sought a senator's phone records. Bondi agreed that such a significant action would typically warrant notification to the Attorney General or FBI Director, but she revealed she and FBI Director Patel had only recently learned of the matter. This admission raised questions about oversight within the Justice Department, with Kennedy hinting that former Attorney General Garland might need to testify to clarify the chain of command. In a surprising pivot, Kennedy shifted to an unrelated but equally provocative topic: an October 1st interview by Secretary Howard Lutnick with the New York Post about Jeffrey Epstein. Kennedy recounted Lutnick's claim that Epstein, his former neighbor, was the greatest blackmailer ever, alleging that prominent figures participated in Epstein's schemes, potentially recorded in a massage room. Kennedy pressed Bondi on whether she had reviewed the interview transcript or planned to interview Lutnick. Bondi confirmed she had seen the clip but had not reviewed the transcript, and she deflected on plans to interview Lutnick, stating it would depend on his willingness and FBI priorities. Kennedy's insistence that Lutnick's allegations warranted scrutiny suggested a broader concern about unaddressed high-profile scandals. The hearing's key arguments centered on the balance between investigative authority and individual privacy. Kennedy argued that accessing senators' phone records required rigorous justification and oversight, warning of a chilling effect if such actions went unchecked. He painted a picture of telecom companies caught between complying with federal subpoenas and protecting themselves from liability, while federal agents risked overstepping their authority. Bondi, constrained by the ongoing investigation, emphasized procedural norms but avoided confirming details, leaving open questions about the Smith probe's legitimacy. No concrete outcomes emerged from the hearing, as Bondi's refusal to discuss specifics prevented definitive resolutions. However, Kennedy's probing highlighted potential vulnerabilities in the Justice Department's processes, raising the specter of future inquiries or legal challenges. The mention of 8 senators' records suggested a broad investigation, but without details, the scope and justification remained unclear. The Lutnick tangent, while tangential, underscored Kennedy's broader agenda of demanding accountability for alleged misconduct at the highest levels. The hearing concluded without a clear resolution, leaving the tension between investigative power and privacy protections unresolved. Kennedy's relentless questioning ensured the issue would not be swept under the rug, as he put it, signaling potential further scrutiny of the Jack Smith investigation and related matters. The exchange, marked by Kennedy's sharp hypotheticals and Bondi's cautious responses, underscored the delicate balance between national security and individual rights, with implications for both the Justice Department and the telecommunications industry.